my story is the continuation of labor moving forward in the cannabis space. It comes out of Ohio. It involves a hospital worker in a hospital, and they called for a random drug test, and he pissed positive for cannabis metabolites. And they suspended him. He can go to a drug class and, promise not to do it again and all that sort of stuff. Well, the union, the Service Employees International Union, they demanded arbitration under their collective bargaining agreement. And the case went to arbitration. The arbitrator found a couple of things. Number one, he found that the collective bargaining agreement called for a reasonable suspicion before you ask for a drug test, not random drug testing. And they also pointed out that the collective bargaining agreement talks about possessing or using or being under the influence of a whole host of substances, including alcohol and marijuana, while you're on the premises. So it turns out that this judge wasn't as dumb as each party thought he was, because this judge pointed out, or the arbitrator pointed out, that metabolites don't mean anything. And this is something we've dealt with numerous times when it comes to charges of driving under the influence, because metabolites stay in the system for as much as 30 days. So if you've got metabolites from cannabis, and typically they're THC metabolites that are in the system, you could have smoked weed the night before or 30 days before. Okay? And it in no way proves that you were under the influence or that you had used on the premises. And the randomness, the reasonable suspicion, the hospital brought forth no evidence in this arbitration to show that there was some kind of a reasonable suspicion that this person had used or was under the influence on their premises. So the arbitration panel, or the arbitrator, said, nah, give the guy his job back, wipe out the suspension, make him whole, because it was the hospital that screwed this up. Well, the hospital went to federal court. And one of the things that we've talked about in the past is that when you forum shop, the federal courts in weed generally turn out to be positive for the people opposing weed. Well, in this case, it didn't turn out that way. The hospital filed a suit, and the union countersued in the federal court, and they both filed for what we call summary judgment, which means there's no contested issue of material fact in this case. So the judge can determine on the paper. Okay. And so what the judge looked at was that the arbitrators, they typically defer to them. This collective bargaining agreement called for arbitration for disputes. And unless the arbitrator is just being fraudulent or dishonest, or is not in any way connecting the decision to the collective bargaining agreement, the federal courts generally go with it. And the court pointed out that there was nothing in this case that indicated that the judge wasn't tying, or the arbitrator wasn't tying this decision to the collective bargaining agreement, and that there was no reasonable suspicion to test him, and that the collective bargaining agreement did not allow random testing. You had to have some reasonable suspicion. These are what we call for-cause testing in the employment setting. And that metabolites don't mean anything. They don't tell you if someone's under the influence, if they had just used. If you were testing for THC levels, that might have a different persuasive factor for the judge. But all they brought forward was metabolites. And it made me think that whoever is trying this case did not understand cannabis, didn't understand the toxics or the intoxicating effects, how the liver detoxifies or anything like that. So I thought that whoever was representing this hospital did not do a very good job of trying to put forth their position. And what the federal judge ultimately said was that the union's going to win here because the arbitrator stayed within the limits of his authority, and that the hospital didn't prove its case. This is one more step towards certifying for workers the right to use substances off the job, especially if they're legal substances. Now, Ohio had just recently passed cannabis legalization. And so one of the arguments the hospital made was that the arbitrator, tied that new law to this decision, and the court said no. But it is good to see that even the federal courts are moving towards some common sense around cannabis. The guy that was in trouble here was called a porter. If you ever been to the hospital, they basically push your gurneys around. Okay? And, pushing a gurney makes you wonder, why are you drug testing somebody who's pushing a gurney? It's probably a little more taxing job and more interactive with patients than being a janitor, but not a whole lot more. So I think this is a positive step for the employment situation around cannabis, and especially off-duty cannabis use. I'm hoping that if we do this again, somebody comes in with some proof, if you will, that this person might have been under the influence and might have been using on the job, because this just was devoid of any evidence to prove that. So it's a positive step for employment rights. I'm going to throw it back to you guys. What do you think about this decision?
Did the unions come out with any comment on this as far as their position on this, Dale?
I haven't seen one yet. No.
I'd be really
interested. It wasn't part of the workup.
I would be really interested to see what the union had to say about this verdict.
Well, and one of the things we've talked about many times, Jason, is that someone who's an experienced cannabis user, for most low-level activities, there really is no reason to question their ability to do it. Mm-hmm. Okay? I mean, if you're the surgeon or if you're the airline pilot or things like that, you might want to just be sure the person isn't drunk or just smoked a blunt or was shooting coke in the hallway or something like that, because these are very high-functioning jobs. Mm-hmm. But for the average person, if you smoke a joint the night before and you show up for work the next day, what's different from that than having a beer or a shot of scotch the night before and coming to work? And that's a little more common sense and realistic to the dangers that this substance might bring to other people you're taking care of, or might put in a position of harm.
Mm-hmm. You have any thoughts on this, Jenny? I know you deal with a lot of employment things.
I do a lot of firing people. Guess somebody's got to do it, right? You know what? This is the first time that the union has been helpful. I've been part of unions, and I'm not a big fan of unionization in instances where people aren't going to die. But I think when we're talking about safety in this sense, then yeah, the union is probably needed. But I think that it's nice that the union steward was actually helpful this time, because usually they just go into meetings and look completely lost. So this is nice.
Fair. Interesting. I wonder, Dale, so we've been covering a story and following along this lawsuit in regards with some New Jersey law enforcement officials who are taken off duty because of their off-duty use of cannabis, and they are currently suing. And we covered this follow-up story yesterday. I wonder if this case is going to have some types of repercussions that case is going to have to look at.
Well, these are district court decisions, and they're not as persuasive as an appellate court or a Supreme Court decision. Mm-hmm. But it's just more evidence that I think common sense is coming to the cannabis space, as opposed to knee-jerk reactions that, oh, this is illegal, we're just not going to even discuss it. Mm-hmm. Moving beyond that and allowing people to come forward with evidence. Mm-hmm. If you're saying that I'm a bad person because I smoked weed the night before, then prove it, and don't bring your dog and pony show in. Bring evidence, bring experts, something.
Yeah.
And the cops, the same thing. I've represented cops before, and I find them to be generally decent people. They're trying to do the right thing here. Mm-hmm. And, if you can find a way to relax from being a cop by smoking a joint the night before you go to work, I don't see how that should affect your next day's performance. And those of us who have been experienced with cannabis know that what you do the night before with cannabis very rarely affects you the following morning. Mm-hmm. So it's common sense, I would hope. And as I recall, the cop thing had to do with being able to have a gun and the violation of the federal law around guns and Schedule I drugs. So I don't know if we're going to fix that, but common sense needs to come into these cases.
I agree with you on that. There's, what they say, Dale, if common sense was so common, ...
Well, but if humans were angels, we wouldn't need government either.
Oh man.
There's a whole bunch of
saying. There's another saying, Dale, that goes along with that. It's if tits and ass were dick and balls, then my mother would be my father.
Yeah. Well, it depends on where you live. That might be a funny knee-slapping story.
That's not usually how it.
Man. That's not how it goes,
Like
Jenny?
it's
No,
shot.
it's not.
Oh, how does it go then, Jenny?
I don't remember, but it's not tits and ass and dick and balls. It was a little less vulgar than that. It'd be my aunt, be my uncle.
I don't buy that.
Yeah.
I've
If my aunt had balls, she'd be my uncle. Is how it goes.
No, I've only heard the vulgar version, just like how I said it.
That's gross.
You're wrong.
Congratulations.
It's all right. We're going to go to a commercial, though, and we're going to be right back.